Welcome, esteemed members of the jury and fellow armchair attorneys, to another riveting episode of Decoding Lawsuits, where we include dissecting the juiciest scandals and make light of society's darkest corners. In this video, we're tackling a case that's got more twists than a pretzel factory run by contortionists, the newly declassified Epstein files. Ladies and gentlemen of the court, prepare your gavels because the Department of Justice just dropped a bombshell bigger than my ex's alimony claims, or so they might tease. On February 27th, 2025, they released a batch of documents about everyone's least favorite financier turned felon, Jeffrey Epstein. Now, I know what you're thinking. Didn't this guy check out of Hotel Earth years ago? Well, apparently, his legacy is the gift that keeps on giving, like a Ponzi scheme that refuses to collapse. Let's examine the key players in this legal drama, shall we? Our star witness is none other than Attorney General Pam Bondi, who's been pushing for transparency harder than a teenager trying to clear their browser history. She's got the FBI director, Kash Patel, on a short leash, demanding he dig up every last scrap of info on Epstein, digging up every single thing Epstein has thought of having. But here's where the plot thickens like a poorly mixed batch of concrete evidence. Bondi claims the FBI's been holding out on her, sitting on thousands of pages of documents like they're guarding the secret recipe for Coca-Cola. This raises serious legal concerns regarding governmental transparency and public access to critical case files. Under the Freedom of Information Act, or FOIA, federal agencies are required to release requested documents unless they fall under specific exemptions, such as national security or personal privacy. The question is, are these legitimate exemptions at play, or is the FBI deliberately overcomplicating the handing of key details to protect high-profile individuals? She's given them until 8 a.m. sharp to cough up the goods.
Well, I suppose that'll save Hamsterfield the trouble. Now hand them over.
I haven't seen a deadline that tight since I tried to return my pants to the store after Thanksgiving dinner. However, setting such a deadline on document declassification is unprecedented. Typically, FOIA requests and declassification processes take months or even years. Bondi's aggressive timeline suggests either a pre-existing internal review or external political pressure. If the FBI fails to comply, the legal recourse could include congressional subpoenas or even a contempt of court charge, raising the stakes significantly. Now, let's present Exhibit A, the contents of these files. We've got flight logs that read like a who's who of the rich and infamous, a contact book that puts my high school yearbook to shame, and a financial paper trail that could implicate more than just Epstein's inner circle. One of the most damning revelations is a series of offshore transactions between Epstein's estate and unnamed entities in jurisdictions notorious for money laundering. This raises significant questions about whether accomplices or enablers are still operating under the radar. The real smoking gun? An evidence list that includes items that would make even the kinkiest among us flush the blood out of our faces. We're talking CDs labeled Girl Picks, copper handcuffs, and enough toys to stock an adult store. Legally speaking, the presence of such items in an investigative file does not necessarily constitute direct evidence of criminal activity, but it does support the already well-documented pattern of Epstein's predatory behavior. The bigger issue here is whether this evidence was acted upon in real time, or if law enforcement agencies ignored it. If there was deliberate inaction, this could open the door for obstruction of justice charges against individuals within the FBI or other departments. Now, that office chaos could potentially be on the level of the chaos that ensued in Trump's meeting with Zelensky. Your Honors, I'd like to draw the court's attention to the fact that this release is just phase 1. That's right. It's like a Marvel movie franchise, but with less spandex and more subpoenas. Bondi's promising us a sequel that'll make The Empire Strikes Back look like a teaser trailer. Legally, a phased document release strategy is often used in cases involving large-scale corruption or organized crime. This suggests that the Department of Justice may be holding on to more sensitive information that could be used in ongoing prosecutions. The existence of Phase 2 implies that not all implicated individuals have been revealed yet, so the real legal fireworks may still be ahead. Now, I know what you're all wondering, esteemed members of the jury. What about the big names, the A-listers, the people we actually care about? Well, I object to your disappointment because this first batch is about as revealing as a magician's trick manual. We've got some familiar faces on our list, like Bill Clinton and Prince Andrew, popping up in those flight logs. But let's be real, we've known about their frequent flyer miles on Air Epstein for years. But what does it mean legally? Flight logs alone are not definitive proof of criminal involvement. involvement. Prosecutors would need corroborating evidence, such as testimony, financial transactions, or surveillance footage, to establish culpability. The biggest legal hurdle is linking these individuals directly to Epstein's criminal enterprise, rather than merely associating them with him socially. This is where the second wave of document releases could be crucial, if it includes concrete proof of illicit activities involving high-profile figures. But don't lose hope, dear legal buddies. Bondi's on the warpath, accusing the FBI of playing hide-and-seek with the really juicy stuff. She's got Patel scrambling like a short-order cook during the breakfast rush, promising there'll be no cover-ups, no missing documents, and no stone left unturned. However, the promise of full disclosure clashes with historical precedent. Cases involving powerful individuals have often led to classified document redactions or strategic leaks that obscure more than they reveal. If Patel fails to deliver unredacted evidence, he could face legal challenges that question the integrity of the FBI's investigation. Let's approach the bench and appreciate the irony here. We've got a Republican administration falling over itself to release documents about a guy who rubbed elbows with everyone from Donald Trump to Bill Clinton. This inter-party struggle over transparency presents a unique legal conundrum. Should justice be blind, or does political convenience determine when and how the truth emerges? Historically, legal battles over classified information often become tools for political warfare rather than pure legal inquiry. But here's the million-dollar question, counselors. Will these documents actually tell us anything we don't already know? Or are we just rehashing old news, like a rerun of Friends, but with less Ross and more remorse? Some critics are already calling this release a complete disappointment. It's like expecting a gourmet meal and getting a lukewarm TV dinner. We've got flight logs that read like the guest list for the world's most uncomfortable party, financial records suggesting systematic hush money payments, and testimonies from former Epstein employees that could be admissible in future civil lawsuits. And here's more. We've also got a bag of cash dated to when Epstein was in jail. Because nothing says, "I'm innocent," like mysterious envelopes full of money, am I right? This is significant because it suggests Epstein was still financially active while incarcerated, raising questions about who was managing his assets and whether they were complicit in ongoing criminal operations. If traced, these transactions could lead to further indictments. Now, I know some of you might be thinking, "Objection, Your Honor? Shouldn't we be taking this more seriously?" And you're absolutely right. Behind all the salacious details and celebrity name-dropping, there are real people who suffered real harm. From a legal standpoint, the most important aspect of these document releases is whether they contribute to justice for the victims. Many survivors have ongoing lawsuits against Epstein's estate and associated individuals, and new evidence could strengthen their cases. So, what's the verdict from all this? Legally, we're at a crossroads. Either this release paves the way for further prosecutions, or it becomes another example of justice delayed, justice denied. As we adjourn tonight's session of Legal Suit Decoded, I leave you with this closing argument. In a world where truth is often stranger than fiction, sometimes all we can do is laugh, learn, and hope that justice eventually prevails. Court is now adjourned, ladies and gentlemen. Keep your documents declassified, your subpoenas ready, and your eyes on Phase 2, because that's where the real battle for justice begins. See you on the next video, and do remember, in this courthouse, we listen, and boy, do we always judge.